we're on the record for this Wednesday morning's civil docket for June 23rd, 2021. I will start with quick announcements. Ms. Olson?
Good morning, Judge. I am here on number 1 on the court's docket, CL 15-2262I.
Okay, portfolio recovery versus Maite Aguilar. And what is your announcement, Counselor?
This one, Your Honor, has settled, and we have filed a notice of non-suit, but it looks like I see a note on the court docket. It looks like it needs to be refiled with the party's name, so we will get that refiled today.
Okay. I'll go ahead and just set a tickler for July the 9th just to make sure that it's been done. And as soon as you file it, I'll have it sent over to my queue.
Okay. And
okay. Anything else?
Yes, Your Honor, I'm also here on number 12 on the court docket. I do see opposing counsel is here as well. In this case, it looks like we previously had a motion for default judgment, but it has since been vacated. So if opposing counsel agrees, I think we just need to set it for a trial.
Okay, that is CL 161097-I. Portfolio recovery versus Reynaldo Robles Jr.
That's right. This is Julie Balovich. I'm the defendant's attorney. After the default judgment was vacated, there was an order setting hearing on a default judgment that was submitted. I don't know if that was by accident or how that was submitted.
Yeah. Apologies, that was a mistake. Yep.
Yeah, no, I'm sure. I didn't think so. But right, so it's not a default, so it just need to be set for trial.
Okay, so then are y'all going to start working it up for trial?
Yes, if we could get something maybe 90 days out to give us an opportunity to talk and maybe get it resolved.
And do you want a bench trial or do you want a jury trial?
We're good with a bench trial.
We're not going to ask for a jury.
Okay, so then why don't we see where you're at in about 90 days from now?
Okay.
Let's come back on September the 29th at 9:30 a.m. And then at which time I expect that you'll be ready for a bench trial date.
Okay.
And if you do need to mediate this before you go to trial. So if you need the court's assistance in having a mediator assigned, let us know. Otherwise, I'll give you an opportunity to agree amongst yourselves.
Okay.
Your Honor, just one thing, because of the pleadings on the portfolio attorneys, I just wanted to confirm with Ms. Olson who I should be communicating with.
You can communicate directly with me.
Okay.
And I will leave, I will send you a chat with my email address and
That's terrific. Perfect. Thank you so much. That's all I have, Your Honor, on the docket. After I get that information from Ms. Olson, may I be excused?
You certainly may.
Thank you, Judge.
Okay, Ms. Olson, anything else?
And I have one more matter. We may have coverage on this one, but it's number 14, CL 196425I.
I'm also here for that, Judge, as previous counsel. So I can either cover it or if you want to handle it, either way, it's fine.
I can make an announcement, but you can still invoice.
Go ahead.
Okay, Judge, on this one, we are set for a status conference. We did file a motion for a default judgment, so we are ready to proceed on that. So we either can proceed on that today or we can set it for a default hearing.
Okay, did you file an order setting hearing with that default judgment?
I believe that should have been filed as well.
I don't see one on file, Judge.
If not, we can get that order. We can file that today with the non-suit.
Okay, because I don't see that it's been filed, but if you want to go ahead and file your order setting hearing on that default judgment, we'll get it set.
Okay.
And we'll go ahead and take it up at that time.
Okay, and those are all of the matters I have before the court today. May I be excused?
You certainly may.
All right, thank you, Judge.
Thank you. Okay, Attorney Mark Montalvo.
Good morning, Your Honor. Number 15 on your docket, CL-20-3026-I. And I've seen all council present, Mr. Fryer and Mr. Hernandez. This is a status conference, Your Honor.
Okay, that is L&R Ready Mix versus Holchimont Limited et al. And what are the announcements, counselors?
From my part, Your Honor, on behalf of Holchimont, we are conducting discovery right now, still in the process of getting some information. After this round, from our point of view, we'll be ready for dispositive motions. I can't speak to the rest of council's plans at this time, though.
Okay, Mr. Hernandez?
Judge Jose Hernandez here on behalf of L&R Ready Mix. Judge, simply, yeah, Mr. Montalvo was correct. We're in the process of written discovery. And I think maybe since all parties are here, I think if the court could set us up for a DCC so just we can get on the jury trial docket.
Okay, and what about, have you all, how much time do y'all need to conclude your discovery and be ready for mediation?
Judge, I think Mr. Montalvo has sent out written discovery. I'm in the process of sending discovery out to him. And I think it's just written discovery and maybe a deposition or two that needs to take place. And it's just simply, it's a case in regarding non-payment of some materials delivered to a project site. So it's going to be, pretty much some of the principals just testifying as to payment and delivery. And so I think maybe one or two depositions plus written discovery will take care of it.
Your Honor, I would say based on that, in order to review discovery, he hasn't sent it out yet to me at least. And then to respond and any depositions and then to file dispositive motions, I would say a minimum of 90 days from now.
I would agree. I'll have y'all come back for a second status on September the 29th at 9:30, at which time I should be prepared to be able to give you a DCC date. And I should have the jury trial dates available to me by that time.
Third judge.
Very good, Judge. That's all from me, Your Honor.
Likewise, Judge, that's all before the court, I think.
Okay, if that's all you have, you may
Thank you,
be.
Judge. May we be excused?
Thank you, Judge. Can I be excused?
You certainly may.
Thank you.
Thank you, Judge. Be safe.
Likewise. Okay, Attorney Claire Portis?
Yes, Your Honor, I have number 7 on the docket, TD Auto Finance versus Jose Sanchez.
Okay, CO 191412-I, TD Auto Finance versus Jose Sanchez. And what is your announcement, Counselor?
We filed a motion for default judgment back in August of 2019, but we have not filed an order setting hearing. So if the court could retain on the docket for 30 days, we'll get that on file.
Okay. Okay, that'll be fine. Go ahead and get that order setting hearing filed as soon as possible.
Thank you, Your Honor. That's all I have for today. May be excused.
You certainly may.
Thank you.
Thank you. Attorney Carlos Galvan?
Good morning, Your Honor. I have number 16 on your docket, and I believe opposing counsel is present.
Okay, CO 204121-I, Adolfo Ruben Sanchez versus Katia Melo.
Your Honor, Carlos Galvan for plaintiff.
Nasser Onala for defendant Katia Mello.
And Your Honor, in regards to this case, we have already conducted written discovery. We have exchanged dates for depositions. That's the next step. So we're still early in this case, Your Honor.
Okay, any additional announcement from the defense?
No, he summed it up pretty nicely.
Okay, so, and what about mediation? When do you think you'll be ready to attend mediation?
It depends on when we get the depositions done. If we can get them done in the next 2 months. I think I saw Daniel Hernandez on if he wants to mediate for us. He can give us some dates and Carlos is okay with that. I'd be okay with that as well.
Okay, let me go ahead and have you mediate this within the next 90 days with Daniel Hernandez, get with his office to get some dates. And then we'll have you come back on September the 29th for a second status and to let me know if it's settled or how we're going to proceed on this case.
That works, Your Honor. Thank
you, Your
you.
Honor.
That's all I have this morning. May I be excused?
You certainly may.
May I be excused as well, Your Honor?
You certainly may, sir.
Thank you, Your Honor.
Thank you.
Okay, Attorney Christopher Castillo?
Good morning, Your Honor. Number 10 on the docket.
Good morning, sir. CL 142359-I, Robert Gonzalez versus Noelia Gonzalez.
Yes,
Good.
Christopher Castillo here for the plaintiff, Your Honor.
Good morning, Your Honor. Joe Gomez for the defendant.
Your Honor, this is a status hearing set for today. All we're asking for this morning is just a setting for a jury trial.
Okay, Mr. Gomez, any additional announcement?
That's correct, Your Honor. We have mediated the case twice unsuccessfully. So yes, we're asking for a jury trial.
Okay. So you'll probably be one of the first to go that I send to go because it's a rather old case. So I'm hoping that I'll be able to have a better picture as to where we're at with jury trial settings. But the best I can do is have you come back on the 29th. And that should give me some time, all of us some time to see where we will be with respect to jury panels.
Okay.
So just come back on September the 29th at 9:30. Okay, anything else, gentlemen?
That'll be it. May I be excused?
You certainly may.
All right, thank you.
Okay. Attorney Victoria Flores?
Good morning, Your Honor.
Good morning, ma'am.
I'm here on number 9 on your civil docket.
Okay, that is CL 196159-I, Gales of West Virginia versus Jordan Del Valle. I saw Mr. Kirstein on.
Yes, Your Honor.
Okay, and what are the announcements, counselors?
Your Honor, we are set on a motion for summary judgment this morning. It was plaintiff's motion. We did file a response, and today's hearing was carried over from May the 24th, Your Honor.
Okay. I believe Mr. Kirstein did, the last time that we were here, or whatever, have you had an opportunity? Can you please refresh my memory if you've already argued the motion?
No, Your Honor, we did not argue the motion.
Okay. So let me go ahead and we'll take that up shortly. Let me recall you, okay? So I can take up your argument.
Very good.
Okay. Okay, Attorney Raul de la Garza?
Good morning, Your Honor. We're here on number 11 on your docket, and Miss Ashley Cedillo is here.
Okay, that is CL 144356-I, Rosario de los Santos versus Victoria Gonzalez.
Raúl de la Garza for the defendant, Your Honor.
Ashley Cedillo for the plaintiff.
Okay, and who's here for the plaintiff?
Ashley Cedillo, Your Honor.
Oh, I can barely hear you, Miss Cedillo. Can you raise your volume?
Yeah, let me see. Can you hear me better, Your Honor?
A little bit, but as long as my court reporter can hear you. And what are the announcements, counselors?
Your Honor, we're here on a status. This is a motor vehicle accident. We have exchanged written discovery. We've taken depositions, retained experts, and unsuccessfully mediated this case, Your Honor. It was set for trial earlier this month, and we are here asking for a decency.
Okay. Ms. Cedillo, anything to add?
Your Honor, the only discovery that needs to be conducted left is the defendant's deposition. Date requested for that was sent out several months ago.
Okay. Mr. De La Garza, did you hear that?
Yes, Your Honor, I did. Well, if you can please, we'll go ahead and try to get with our client and get him dates.
Okay. So I guess you all will get that scheduled. Okay, well, you heard the announcement, so I'll have y'all come back on September the 29th at 9:30, at which time hopefully I have a better direction.
Yes, Your Honor.
Understood. And will that be for a DCC, Your Honor, or a status?
No, that'll be a status. And then I should be able to start handing out those DCC dates like hotcakes, hopefully.
And that's the 29th, Your Honor, September 29th?
Yes.
Understood. Thank you very much, Your Honor. That is all I have here today. May I be excused?
You certainly may.
Your Honor, that concludes my business in this court. May I please be excused?
You certainly may.
Thank you, Your Honor.
Okay. Thank you. Attorney Francisco Martinez?
Good morning, Judge. I see Mr. Guerrero's on the screen, but his chair is on the screen, not him. So I'm waiting for him to.
They usually have somebody listening in his office because he's in several courts.
Yes, ma'am.
Okay. So what are you on here on?
Judge, we have number 18 on your civil docket, Attorney Francisco Martinez for Mr. Arturo Garza, I'm sorry. Judge, with the court's permission, we agreed to pass this this hearing. We did file a Rule 11 this morning. I understand the system was down yesterday and we couldn't. But that would allow us a little bit more time to hopefully reach some type of temporary agreement.
Okay. Have you all, are you all going to mediate this or are you informally mediating?
We can mediate, Judge. That's fine. I have explained it to my client. But that's a possibility.
Okay. Well, in order for you to have a contested hearing on your temporary orders, if you do decide to have a contested hearing, I won't entertain that hearing unless you've already mediated it.
Okay, I'll discuss it with Mr. Guerrero, Judge. If we can reach an agreement without a formal mediation, great. If not, we'll set up something immediately for mediation, formal mediation.
Okay, then how much time are you going to need? Because I'm going to either reset you on your temp orders or I'm going to set you on status.
Oh. I'm not sure what Mr. Guerrero would. I don't want to answer for him just on that.
Okay. I know, is Mr. Guerrero in another court right now?
He is, Your Honor.
Okay. Okay. Well, I don't know if you want to ask him if he wants to reset the temp orders or if I go ahead and set for status, but you will be required to attend mediation prior to coming back for any contested hearing. So I'll give you a few minutes and just let me know, Mr. Martinez, when you're ready, because I'm not going to let you go without giving you another date.
Yes, ma'am. If they can just let them know that I'm okay with mediation, formal mediation.
Okay. So then what we'll do is I'll go ahead and reset your temporary orders hearing, at which time either you'll mediate prior to that date. And if you have something if you all reach an agreement, I do allow your agreed temporary orders signed off by all parties and by attorneys to be submitted without needing to prove up the temporary orders. And you can pass that hearing at that time. Or if you need a contested hearing, I won't entertain you unless you have already mediated it. Okay?
Understand, Judge. Understood.
Okay, so I'm going to have you come back. Give me a moment. I'm going to have you come back on July the 7th.
Okay.
And I'm going to set you at 11.
Yes, ma'am. Got it.
If you want to mediate this informally, you can. If you mediate it formally, then you are to mediate it with Catarina Alvarado.
All righty, Judge. Got it.
Okay?
Yes, ma'am. That's all I have this morning, Judge. May I be excused?
Yes.
Thank you.
Okay. Thank you. Okay. Mr. Ben Guerra.
Good morning, Your Honor.
Good morning, sir.
I'm here on number 6 on the court's docket, CL 162667-I.
Okay, and who do we have as opposing counsel on this?
There is no opposing counsel on this one, Your Honor. This is a post-judgment application for turnover and a receiver. If I may, Your Honor, can I have Redlow called out? However that works out through Zoom nowadays.
Yes. Okay. So then, who is left standing on the defense?
It's Redlow Inc., who is unrepresented.
Okay. And what is the situation? So then, with the defendant Sergio Ramirez, ANS Communications, Anacleto Lopez, and Juana Lopez, that has nothing to do with them today.
That's right, Your Honor. Those matters have been resolved separately, either through settlement or other judgments.
Okay. So, Mr. Damian, can you please call out Redlow Inc. 3 times?
Yes, ma'am.
Redlow Inc., Redlow Inc., Redlow Inc.
Okay, anybody here representing Redlow Inc.? Okay, no one is here representing Redlow Inc. Did proper notice go out, Mr. Guerra?
Yes, Your Honor. We've been sending the notices out to Redlow Inc. to its registered address and the address that appears on the Hidalgo County Appraisal District website. If I may give the court just a little bit of background on this case. This is a case that was transferred over from County Court number 8. This case involves injuries that were sustained by Ms. Nunez. She was shot in the leg in a parking lot of Envidia's Gentleman Club, which is located at 911 Valde Road in Donna. It's a 1.6 acre tract. It's right off the expressway. The property is owned by Redlow Inc. It was one of the defendants in the lawsuit. The company has forfeited its charter back in January of 16 and hasn't been reinstated. So we served Redlow Inc. through the Secretary of State, and we've been sending notices again to its registered address and where it receives mail from the Hidalgo County Appraisal District. At the default judgment hearing back in October of 18, we put on evidence that there was a lot of criminal activity that was going on there at the property. And on October 1st of 18, we obtained a default judgment against Redlow for $212,010 for actual damages and $200,000 as exemplary. So the total judgment is $412,010. And we recorded the abstract in October of 18. So this application, Your Honor, is an application to appoint a receiver. The judgment is still valid. It hasn't been paid. We haven't collected on any assets from Redlow. And in order to be entitled to a receivership and a turnover, we just have to show that the judgment's unsatisfied and that the defendant owns at least one non-exempt asset. The non-exempt asset that Redlow has is the property where the event happened, where the shooting happened. We filed an application. Attached to the application, Your Honor, Exhibit A is our judgment. Exhibit B is a post-judgment discovery that we sent to Redlow in December of 2019, and there was no response. Exhibit C are the corporate records from the Secretary of State showing that it was forfeited in January of 16 and hasn't been reinstated. And Exhibit D is the warranty deed from the Hidalgo County Clerk's Office and a printout from the Hidalgo County Appraisal District showing that Redlow is the owner of that property.
Mr. Guerra, before you continue, when did you file your plaintiff's application for turnover relief? What's the date you have on there?
Well, the date is May 18th, 2021. And
because I don't see it in the court.
If you go into the -1, because there's three cases total with this case. So there's two related ones. The -1 has been disposed of, and that's the one that the order is signed under. And it was signed on June the 4th. This case was transferred from court 2, I believe.
Okay, you mean I?
I-1, and then there's an I-2. And this one is under I-1.
Okay, hold on.
And if Your Honor would like an explanation, I can try to explain what happened with that.
Well, I'm more curious at this point to find the correct case.
Right.
Okay, so, okay.
If you go into the regular case, the seal 162667-I, on the right-hand side, Judge, it says related cases.
Yes, I found it. Now I see all his exhibits that he's talking about. Okay. Okay. Okay, you can continue, Mr. Guerra. Go on.
Apologies, Your Honor. And just to be clear, what happened is the County Court 8 had transferred the -I to your court, but it was a question as to whether the -H1 was transferred. So we filed it under H1, and then County Court 8 said, no, it's all of the case. And so it transferred the -1 to you. And so that's the explanation that I have for that. But as I was mentioning, Exhibit D shows that Redlow Inc. is the owner of that property. And then Exhibit E is the declaration and the resume of Gina Laguna from the Dykema law firm, who has agreed to act as receiver in this case. We'd ask the court to admit Exhibits A through E into evidence.
Well, okay, yes, that'll be so admitted.
Thank you, Your Honor. So as the evidence shows, Redlow Inc. owns this property. We'd like for the court to appoint a receiver to take over that property, try to sell it to satisfy the judgment. In this situation, because Redlow Inc. is a forfeited entity, it can't do it on its own anyway. It couldn't sell the property even if it wanted to. So we're asking that the receiver receive a fee equal to 25% of all proceeds that come into her possession, which will be taxed as cost of court. Although no bond is required under the statute, if the court is requesting a bond, we'd ask that it be set at $100. And we're requesting that Ms. Laguna be appointed receiver. She's actually on the hearing as well.
Good morning, Your Honor.
Good morning, ma'am. Okay, well, I have to say this is very interesting. So I was reading that. So, okay, the court will consider take judicial notice of all the documents that are in the court's file, and that defendants were properly served, Redlow Inc., and failed to appear today. And the court has considered the pleadings and the records on file and is of the opinion that the application should be granted. The receiver shall be appointed. The receiver shall be Attorney Gina R. Laguna of the firm Dykema Gossett PLLC, and she will receive the compensation as set forth by Mr. Guerra. Now, the order that is on file with the court, is that the order that you want signed, or did you need to do any additional changes?
That's the order we would like signed, Judge. The only blank that's on there is for a bond. And again, if the court is asking for a bond, $100 is what we'd ask for.
Okay, I'm not going to require a bond since it's not statutorily required.
Thank you, Your Honor. That aside, that's the order that we would like entered.
Okay, I'll insert 0 on the bond. Okay.
Thank you very much, Your Honor.
Okay, I'll ask for that to be forwarded to my queue, and I'll sign off on it, and you should be getting it soon.
Thank you very much, Your Honor. That's all we have. May we be excused?
You certainly may.
Thank you, Your Honor.
Okay. Have a good day.
You too.
Okay, Attorney Juan Ramos.
Good morning, Judge. I'm here. Give me 1 second. I have the docket number. I apologize.
Is it number 5?
I'm here on number 5 on your docket. Yes, Your Honor.
Okay, F 346129 in the matter of the marriage of Cynthia Cardona versus Jose Cardona Jr.
Yes, Your Honor. Juan Ramos here on behalf of Mr. Jose Cardona. He's the petitioner in this matter, Judge. We're respectfully asking for a continuance. The Attorney General, I believe, is calculating the child support amount in this case.
Yes, Your Honor. Good morning. Elias Alcantara, Office of the Attorney General.
Okay. And what about Ms. Cardona?
She's currently
there. I see her on the, oh, there she is.
Okay, it says you need to be on the camera, ma'am.
Good morning.
Okay. Good morning. Okay, and so the AG's office is currently calculating the child support?
Yes, Your Honor. We submitted the pay information last week. I believe the Attorney General's office is still calculating that amount.
Your Honor, we do have some numbers, but we still need to work out the retroactive child support as well. That's the issue that we're still facing.
Okay. So this is styled as a divorce. Are we here on a post-divorce matter?
No, Your Honor, that there was a previous child support order in place that was we merged into this case. We consolidated, Your Honor.
Okay. Okay, so how much time are you needing, Mr. Ramos?
Perhaps 30 days, Judge.
Okay, July 21st at 9:30 a.m.
We'll be ready by then, Judge.
Okay,
Thank
Ms. Cardona, are you going to continue representing yourself, ma'am?
Yes, ma'am.
Okay. Well, then stay in contact with the AG's office and with Mr. Ramos.
Yes, ma'am.
All right. So then
Thank
we'll
you.
see you back here on July the 21st at 9:30 a.m.
Okay, thank you, ma'am.
I have nothing further, if I may be excused.
You certainly may.
Thank you, Judge.
Okay.
May also be excused, Your Honor.
You certainly may.
Thank you, Judge.
Okay. Attorney Daniel Hernandez.
Good morning, Judge. Opposing counsel is on the Zoom. We're number 8 on the court's docket. This is a contested matter involving 3 motions. A motion to compel discovery responses from the defendant, which is plaintiff's motion. Plaintiff's motion to compel numerous various depositions, which is plaintiff's motion. And then a plaintiff's motion for sanctions and to compel the corporate representative, Your Honor.
Okay. And Mr. Lawrence is present?
Yes.
Yes, Your Honor, I'm here. For some reason, the camera on my computer isn't working at the moment. I apologize.
Okay, that's fine. Then let me just see if the other matter that we have pending is contested, and then I'll take you up shortly. So I'll just recall you in just a bit.
Yes, ma'am. Thank you.
Okay. Mr. Hinojosa?
Yes, good morning, Judge. Evelyn Hinojosa, we're number 17 on your docket, Judge. We are contested. Pete Espinosa is opposing attorney, and he texted me earlier that he's in another court, Judge. There are several motions that are pending.
Okay. And that's with Ms. Gomez and Mr. Gahin, is that correct?
Yes, Your Honor, my client is Mr. Guillen, and Mr. Espinosa's client is on the Zoom screen, Judge.
Okay. And have y'all already attended mediation, Mr. Hinojosa?
No, ma'am. We have not, Judge. That is one of the issues bringing before the court. We have not mediated. This is going to be temporary orders contested. Then there are some other motions before the court also, Judge.
Okay. All right, then I'll wait for Mr. Espinosa to come on, but as you heard me earlier, Mr. Hinojosa, I'm not going to entertain any contested temporary orders unless you all have mediated the matter.
I understand, Judge.
Okay,
I'll wait
so,
for
but we'll wait for Mr. Espinosa to come on. Let me go ahead and take up the other 2 contested matters. And if if Mr. Espinosa jumps in, I'll pause it so that I can assign a mediator to you all and you can get working on that.
Thank you, Judge. Judge, if Mr. Espinosa does not show up by 10:30, it might be temporary excused to do a Zoom hearing in County Court 5, Judge.
Yes, sir.
Thank you, ma'am.
Okay. So before we continue with the matters that are contested, let me go to CL 153811-I Juan Hernandez versus Joe Luna et al. Do we have anyone that has appeared on that? Okay. Mr. Damian, please call out Joe Luna and Guillermo Pulido 3 times.
Yes, ma'am. Joe Luna, Guillermo Pulido. Joe Luna, Guillermo Pulido. Joe Luna, Guillermo Pulido.
With no one appearing for either the plaintiff or the defendant, this matter will be dismissed for want of prosecution. CL 161738-I Juan Javier Trevino versus Wellington Insurance Company. Has anyone called in on that matter?
Not this morning, Your Honor. They did email me yesterday asking for the Zoom link, but we haven't had anything this morning.
Okay. Mr. Damian, please call out for Wellington Insurance Company.
Yes, ma'am. Wellington Insurance Company. Wellington Insurance Company. Wellington Insurance Company.
And no one appearing for the plaintiff or the defense, this will be dismissed for want of prosecution. F 3033-20-9 in the matter of the marriage of Oscar Zamora versus Kayla Lozano. Mr. Zamora, I do see you present.
Yes, ma'am.
Was Miss Lozano coming on today?
No, I don't know. I don't have contact with her.
Okay. Well, you had filed for a divorce.
Yes, ma'am.
Okay, so Miss Lozano, did she sign anything?
As far as I know, whenever they went to serve her, she never signed anything.
Okay, sir, let me go ahead and. Okay, so notice was sent to Ms. Lozano and the notice was returned undeliverable. And you had filed your petition for divorce back on August the 21st, 2020,
Yes, ma'am.
okay? And since then, you haven't filed anything else such as a motion, for a default divorce hearing or anything, because you did serve her on August the 27th, 2020. She has not filed an answer. So if you want to proceed, then you do need to file the appropriate pleadings. And since you're representing yourself, you're responsible to know what are those pleadings that you need to file. I can't tell you.
All right.
Okay, I'm going to give you one last opportunity. I'll go ahead and reset you to July the 21st at 9:30. If you don't have those pleadings on file by that time, then, I'll have to dismiss your case.
Okay.
So I would suggest that if you can't do it on your own, that you do obtain counsel in order to assist you.
Okay. All right. I'll do it.
Okay, sir. So we'll see you back here on July the 21st at 9:30.
Okay. Thank you, ma'am.
Okay. So then let me call CL 162091-I, Gisela Solis versus American Modern Home Insurance Company. Did they file a lawsuit on this after all?
Let me check your honor.
Thank you.
Yes, ma'am. No, your honor, they did not.
Okay. Go ahead and set that for the drop docket, the next drop docket. Mr. Espinosa, let me recall your case F3808-18-9 in the matter of the marriage of Blanca Garcia Gomez and Renee Guin. I understand that you all have some contested matters that are before the court. I thought I had made it clear the last time y'all were here as to what the court's position was with respect to co-parenting. But let me know, or Mr. Hinojosa, let me know. Okay, so you're here on temporary orders and you filed a motion to appoint a guardian ad litem and also a motion to enforce division of property. Is that correct?
My motion is for the temporary orders, temporary orders, and I believe, I think the guardian ad litem, but the other motions are Mr. Espinosa's.
Morning, Judge Peter Espinosa for Blanca, who speaks Spanish. And
what motion do you have, or what pleading do you have before the court, Mr. Espinosa?
we had a motion to divide the assets. The divorce had a retirement account that we were still pending division.
Judge, if I may respond, that's basically covered by section 9.102 of the Texas Family Code. Since it's already been, time has elapsed, a petition needs to get filed, original petition needs to get filed and serve my client on a division, or basically prepare the quadro. I can't agree with their pleadings because of course they have not complied with 9.102 of the Texas Family Code. That's one aspect. And Mr. Espinosa has Now, if he wants to prepare the quadro, he can prepare the quadro on his client's benefit, but I'm not ready on that. My client has not been served, Judge.
Okay, either way, I'm not gonna entertain a motion, your temporary orders motion unless you've already mediated the case. And you haven't mediated that. So I don't have an issue taking up, the easy one to me is the ad litem. Are y'all not agreeing that an ad litem needs to be appointed?
We have no objection, Judge. We think that's the best interest. The only problem is, of course, that the Pete's client, Mr. Espinosa's client, does reside in Bexar County, San Antonio, Texas, and has some of the children. And my client resides here in Hidalgo County and has the oldest child is in his possession. So technically there's a split. So there may be a travel cost to Bexar County or whoever the guardian does, or whoever the guardian line appointed, there may be that extra cost.
Okay, and who filed the motion for the ad litem?
I'm taking a look, Judge. It's usually something I usually file on cases involving possession, access, and custody. So I'm trying to look if I did or not, Judge. I apologize. I don't have the motion in front of me, Judge.
Judge, I don't have that on my file as a motion we filed, so it may have been Mr. Hinojosa's. But I understand the children have been split under agreement. There's an older child, he's a teenager, approximately 17, and he's with the father. And we haven't had any objection to that at this time. We have sent some offers to try to resolve it, but I don't know if we've got a response or not yet.
Judge, it's a custody matter. My client wants conservatorship of the kids. And Judge, we did file a motion for the court to interview the children. That carried over. That was at the last hearing, May 17th. That also got carried over for today's hearing. So today would be a very contested matter, Judge.
Okay, I don't have an issue with interviewing the children. Do you have an issue with that, Mr. Espinosa?
But I'm gonna have to check with my client, Judge. So yes, we do.
It's mandatory, Judge.
What would be the problem for me to interview the children? If I want, what would be the issue?
Well, I'm not sure why it's necessary to get the children involved. We haven't even.
Because your clients are fighting for custody. They are involved. If they don't want them involved, they should come up with an agreement on their own.
Well, and that's what we're attempting, Judge. We've sent some offers. We haven't had any responses.
Judge, it's custody. I don't recall having any written offers by Mr. Espinosa. But Judge, it's custody. My client's asking for receivership. This is not a secret. It's been known since we filed our pleadings. So I don't know why Mr. Espinosa is saying it's like almost unknown.
Okay, on your motion for ad litem, to appoint an ad litem, I don't even see it.
I don't.
Somebody else sees it and can, oh, here it is. Okay. Well, I see an order setting hearing on the motion for appointment of a guardian ad litem.
Your Honor, in the order setting hearing, the language reflects it's an order setting hearing on petitioner Blanca Garcia's motion.
Okay.
Oh. Mr. Espinosa's motion.
Okay, so then Mr. Espinosa filed for the ad litem. But for some reason, I don't see that motion. I just see an order setting hearing. So Mr. Hinojosa, you already said that you don't have an objection to an ad litem being appointed?
No, Judge, not at all.
Have you had an opportunity to review the order on the ad litem?
Judge, not really, since usually we basically see motions first. So if you just filed the order without a motion, Judge, I probably would not have seen it.
Mr. Espinosa, when did you file your motion for appointment of a guardian ad litem?
Well, Judge, I don't even have a record of filing it. I'm not sure how that proposed order setting hearing got filed. So I guess I'm going to ask for the opportunity to file the motion.
Okay.
Yes, Judge.
I'm not going to have any objection, Judge, since it's custody is the issue of the children. So I'm not going to have any objection to it.
I don't have any objection to that either, Judge.
Okay, well, either way, you need to have a motion before, so that I know what relief you're asking for, and then you can submit a proposed order on that. When the proposed order, now that we're in this situation, file your motion on the proposed order. I do want that order signed off by both of you so that you are agreeing to the terms of that order, such as how is the cost going to be divided? And then I will appoint an ad litem for the children. As to temporary orders, and the issues that you have pending, I'm going to order you to attend mediation with Cynthia Cantu del Bosque. And then the earliest I can have you come back is on July 21st and at 11 a.m. By which time I expect that the motion and the amended proposed order signed off by both of you will be submitted to the court. You will have attended mediation, and if you will be having a contested hearing at 11 a.m., please notify my court coordinator so that we can make the appropriate arrangements to set up aside some time for you, okay?
Yes, Judge. Judge, and also for the, my motion that carried over back in May was for the court to interview the children. They're at an age where the court can. What is the court's, I know we're doing Zoom, but how would the court want to effectuate that? And since those kids are, some of the kids are in San Antonio and my client's child is here in the Valley, that should be no problem.
When are they coming to visit mom, the children from San Antonio?
Judge, it's right now, it's the kids got released from school in Bexar County on the 18th of this month. My client does have a summer visitation, should already started. So I instructed my client to go this weekend to pick up the kids. He has till July 27th, Judge, under the order to basically have access to the kids. So I'm going to have my client go to Bexar County this weekend. He's going to pick up his children for summer visitation, and he has to return the kids on July 27th.
Okay, Ms. Gomez, you wanted to say something?
Yes, necesito saber qué es lo que están diciendo sobre mis hijos. Yo hablo español y yo sé que están hablando de ellos, pero necesito saber qué es lo que está diciendo el abogado, porque no todo, no todo lo que dice Guillén es verdad.
Okay. Just let her know, Ms. Castañeda, that they're going to be going to mediation with Cynthia Cantu del Bosque, and they'll return on July 21st. You're on mute.
Ms. Gómez, la corte se está ordenando que va a haber una mediación con la señora Cynthia Cantú del Bosque y regresamos para la próxima corte el día 21 de julio a las 11 de la mañana.
Ok. Quiero decir también que Guillén les está diciendo a mis hijas que él no puede verlas hasta que la corte le dé una orden a él. Que si no le dan la orden a él nunca va a venir a verlas. No las va a ver.
Mr. Guillén is telling the kids that he will not see the girls without an order.
Ms. Reynosa, there should already be an order, so if your client is telling the children anything, tell them to stop.
I will, Judge. There is an order in effect already, Judge.
Okay. And also, just to remind you all, I can provide a translator for hearings such as this, but if you're going to have a contested matter, you need to have your own translator.
Will do, Judge.
So you all need to discuss that. Okay, so I'll see you back here on July the 21st. Please contact Ms. Cantu del Bosque to get some dates and get that mediated.
Judge, on that 21st, does the court also want to confer with the children on that date by Zoom or in person, or how does the court want to do that?
Well, if the children are here, I would prefer to set up a time to see them in person. And we can do that in the lawyer's lounge. I believe that's still open at the courthouse. So we can make the appropriate arrangements. You just need to let my staff know when they are here and available for that.
And Judge, I'll do that, and I'll have Mr. Espinosa online. So when I contact your office, it won't be one-sided. I'll have Mr. Espinosa online. I'll do a joint conference when the date and time for the kids to confer with the court, Judge. I'll do that.
That is fine.
Thank you, Judge.
Judge, if I may also, we had, believe filed a nunc pro tunc divorce decree. I think Mr. Hinojosa may have signed off on it already, so I just want to let the court give court notice.
I did see that.
Yeah.
And if he signed off on it, we had returned it because until today's hearing, so I'll go ahead and request it back to be sent back to my queue and I'll sign off on it.
Very well, Judge. And Judge, for Mr. Espinosa, no, we are picking up the kids this Friday. We're going to my client's tribe in San Antonio to pick up the children for the summer visitation.
Well, Judge, we need to look at that nunc pro tunc decree because there was errors with it to begin with.
It's summer visitation. Judge, this is what I don't want. I don't want my client to go to Bexar County and the mother's not there to release the children. It's a standard visitation order. The lem pro tunc was only dealing with geographic restriction. That was removed. This is a standard visitation order. My client's going up there this weekend to pick up the kids.
What's the problem, Mr. Espinosa?
Well, I want Mr. Gomez to explain. Gomez?
Yo siempre le he dicho a él que nos podemos ver a mitad de camino para que él recoja a los niños de perdido una vez al mes. Siempre se lo he dicho y él no ha querido. Él siempre ha dicho que hasta que la corte no le dé una orden, él no va a venir ni a mitad de camino ni a ningún lado.
Okay, wait. Translate that, Ms. Castañeda.
Okay, that I've always told him that he can come pick up the kids if we meet halfway, and he said that no, he's not going to pick up the kids until there's an order from the court.
Okay, Mr. Hinojosa, you need to explain to him that there is an order. And I'm not going to deal with this, okay? I'm not going to deal with them having attitude with one another, and I'm not going to deal with any games, okay? The last time that y'all were here, I told you all to be reasonable with one another. I told them that they needed to give access to each other if the order called for it. And I'm not going to play any games with the attorneys either. So if you know that the non-pro-tunc only deals with the geographical restriction, then there's no problem with him picking up the children on Friday. Is there a problem? Is there a problem?
Yo necesito que me lo traduzcan.
Ms. Castañeda, ask her if she has a problem with her ex-husband picking up the kids on Friday.
¿Tiene usted un problema con el señor levantando los niños el viernes?
¿Levantándolos o que él venga por ellos a mitad de camino?
Que él va por ellos.
Yo no tengo ningún problema que él venga por ellos. Siempre le he dicho, pero él es el que no quiere.
Stop. Ah, está bien. Ya contestó la pregunta. Okay. There, you have it. Your client is going to go up there and pick them up. Now, she offered to go halfway. Your client apparently gave her some attitude, Mr. Hinojosa, so you need to have a talk with him. So if she's trying to work with him and he doesn't want to work with her because he wants to use the court as an excuse, the court has no problem giving any kind of decision in this case. So now he's going to have to go all the way up there to pick him up instead of going halfway. So
And Judge, I didn't have my client testify, Judge. I didn't want to create a scene right now since we're not doing contested matter. So my client knows the order. I'll give Mr. Espinosa. If we have to go up there, we'll go up there. But I do not know the veracity of what she's saying because I'm not going to have my client. I don't want a shouting match this morning, Judge. So we'll comply with the court order, and I'll get with Mr. Espinosa if we can effectuate an exchange.
We will do the same, Judge.
okay, that's fine. Then I'll see you back here on July 21st at 9:30 a.m. Ms. Castañeda, please let Ms. Gomez know that she's to return on July 21st and please admonish both parties that they need to cooperate with the mediation process.
Ms. Gómez, la corte regresa el día 21 de julio a las 11 de la mañana y necesita cooperar con las órdenes de la corte.
Estoy cooperando.
I'm cooperating, ma'am.
Okay, so then, and counselors, please talk to your clients and make sure that they understand how to behave with this order, okay?
Yes, ma'am.
Yes.
Okay, we'll see you back here on July 21st. You all are excused.
Thank you, Judge.
Thank you.
Okay, let me recall CL 196159-I, Cato's of West Virginia versus Jordan Del Valle. I do see that Mr. Del Valle is on and both attorneys are also on. Ms. Flores, are you ready to proceed? Attorney Victoria Flores?
Good morning, Your Honor.
Oh, good morning, Mr. Flores.
I am present this morning. Thank you for County Court number 9 having me.
Okay, so you may proceed, Mr. Kirstein.
Your Honor, this is actually a very simple matter. The defendant in this case entered into a promissory note purchasing a vehicle with the credit union. That credit union went into receivership. The note was taken in by the federal authority for liquidating credit unions and subsequently sold to my client. The vehicle having been repossessed, there is an amount of money that is still owed on the note, as set forth in the pleadings that I filed. In addition, as the court may recall, originally the defendant did not file an answer. He appeared pro se at the first default hearing in the other court. And immediately after that, he was sent discovery, including requests for admissions. Those discovery requests were signed for by certified mail and delivered to the same address he was served at by the deputy constable. If the court will look at the service documents, you'll see that he was served at the same address that the requests for admissions were sent to. It had been more than 40 days before I filed the motion for summary judgment, and no response was filed to those. Therefore, they should be deemed as admitted. Opposing counsel in his answer has said that the defendant does not live at that address, and therefore he was not properly served. However, there is no affidavit attached to the summary judgment response, so there is no credible evidence to support that. And the matters before the court are the letter that we sent, the cover letter to the proper address, the green card that it was signed, and also I would refer the court to the service return filed by the deputy showing that he was served at that Rebecca Street address with the citation. Now, in addition, opposing counsel has brought up in his response that there was some sort of indictment involving some of the people who worked for the credit union, and that somehow might excuse his client from the debt. However, there is, again, no affidavit filed with that motion for summary judgment response. There is no credible evidence whatsoever connecting this debt in any way, shape, or form to any sort of fraud committed by those individuals. They have been charged in federal court with some sort of crime they committed involving the credit union, but there is nothing to connect this debt with that particular set of actions and or whatever fraud allegedly had taken place according to the federal government, the U.S. Attorney's Office. As a matter of fact, without there being any sort of affidavit attached, I would argue that it's all of those things are nothing more than hearsay, argument by counsel, and can't be given any sort of credibility by the court. And that is basically where we stand, Your Honor. My attorney's fee affidavit is on file. The affidavit of my client representative authenticating the documents is on file as an exhibit with the court. And based on the pleadings, I believe that my client should prevail in this matter and be granted judgment.
If I may, Your Honor.
Yes, sir.
Your Honor, so we're set for a summary judgment hearing today. I would like to remind opposing counsel that in a summary judgment hearing, the court is to assume that all the non-movements proof is true. I don't believe an affidavit is necessary when I've filed the actual indictment that's filed with the Southern District of Texas, as well as the media release, unless opposing counsel is saying that the acting or then U.S. Attorney, Mr. Ryan Patrick, is not filing these things in good faith. I would find that pretty egregious. I've filed those exhibits, the actual indictment. I think opposing counsel is not looking at the fact that those indictments with the debt that is being discussed here, which in my response, I do specifically state there that the bank, it states that he physically went in and signed all these documents. However, that is not true. That presents a genuine issue of material fact which exists. This note, this specific note and the defendant's that are actually charged, not some sort of indictment. There is a indictment present in the Southern District of Texas, which I have attached as an exhibit to my response, alleges those specific persons committed fraud by taking people outside of the dealership and having them sign these documents, which a lot of these folks, the defendant or my client, believe to have been some sort of, financing option. That within itself creates a genuine issue of material fact. The affidavit portion that the opposing counsel brings up, I think my client would absolutely sign an affidavit, which is not required per the rules of civil procedure. And again, he's alleging that the request for admissions was properly signed. I would go back to the Texas Civil Rules of Procedure. Was not signed by the defendant. It was signed by somebody else present there. Your Honor, I believe that there is a genuine issue of material fact that exists here. In fact, that they didn't even know that a lot of these people with the credit unions are involved or charged with the crime with fraud having to do with these notes. And that's a clear defense to what's being alleged here, Your Honor. The bank manager, the finance person overseeing the notes, all of these people are under federal indictment right now for fraud. I'd ask that this motion for summary judgment be denied, Your Honor, as per my response to plaintiff's motion. And further, yes, my client was not represented appropriately before, or not at all, not appropriately, excuse me, was not represented at all. And he sought counsel when he thought that there was an issue, and that's when we came in, Your Honor.
Okay, so do both of you have your orders on file? I do see Mr. Kirstein's order for his proposed final summary judgment motion. Mr. Flores, do you have your order on file?
I'm not sure that I do, Your Honor. I only filed the response. I can file an order though, if you'd like.
Okay, Mr. Kirstein, the order that you want me to consider, is that still the one that you filed on January the 6th?
Yes, Your Honor.
Okay, just so that I can make sure. And Mr. Flores, if you want the court to consider an order denying as well, you can also file your order.
Thank you, Your Honor.
Okay, anything else, gentlemen?
Nothing at this time, Your Honor. Be excused.
Yes, the court will take your arguments and the motions under advisement, and I will tender a decision within the next 2 weeks.
Thank you, Your Honor. Have a good day.
Thank you, Your Honor.
Okay, yes, sir. Thank you. Have a good day. Okay, Mr. Daniel Hernandez and Mr. Lawrence, CL 21-0503-I, Israel Gutierrez versus Eric Delgadillo et al. So have y'all had an opportunity to confer, gentlemen, about these motions?
We have been able to discuss with regards to trying to seek resolution and have not been able to. I got an email this morning and just kind of to shorten at least what we're looking at. I had I guess for a lack of a better term, a document dump on me of more than 650 pages. I think it was last night, Chris, if I'm not mistaken. And that would have been super helpful to have had prior to taking the defendant driver's depot and prior to taking the store manager's depot. So we do have a pending motion to compel discovery, which, I'm not interested in going through and rehashing and redoing and having to come back to the court. So with regards to plaintiff's motion to compel the discovery responses, I would like an opportunity to go through that to see what he's produced. But with the understanding that on these other motions I have with regards to getting depots set, that we have those documents missing before we have these depositions. And I don't want to get the cart before the horse, but that's, I guess, in terms of him reaching out, it was the night before. It wasn't after I got the motion or after I sent a certified certificate of conference to him. So that's what I would say, Judge. I really like to try to burden the court with things like this, but I think these things need to be brought to the court's attention.
Okay, Mr. Lawrence, any response?
Yes, Your Honor. We have complied reasonably with the very, very many discovery requests that have been propounded in this case. 224 requests for admissions, 236 requests for production, 50 interrogatories. We've produced over 850 pages in compliance with that. We've produced by agreement a couple of witnesses at his request, and all within a relatively short period of time. I mean, this case has only been on file for a little bit over 3 months. So, or at least since we filed our answer, for a little over 3 months. So, we're certainly willing to continue to work with opposing counsel with respect to any gaps that he feels, may continue to exist, and, try to narrow the issues as much as we can with respect to, any gaps, as I mentioned, that he perceives that still exist, and try to conduct the discovery without the necessity of the court's intervention.
Okay.
We've also tendered, by the way, excuse me, I forgot. We've also tendered, and I think this is what Mr. Hernandez was referencing to, an additional 3 witnesses to be deposed at his request. And so we're certainly, we'll work with Mr. Hernandez to get those scheduled.
That's news to me, but not to interrupt, Judge, but I would like to proceed with the motion to compel the corporate rep, at least to give an understanding of the court, run through that, if I may.
Okay, so then, Mr. Lawrence, your client has an issue with producing the corporate rep for a deposition?
No, Your Honor, we have filed with the court a tender and identified the witness who we would propose to produce as a corporate rep. The only thing that would remain to be done with respect to that would be to schedule it.
Okay. Well, let me just back up and fill in the gaps. So the gap is this corporate representative, since we're getting in kind of to the motion already, this corporate representative was asked and it was noticed and it wasn't presented. I really like to get into showing now. He's now saying he's produced names of folks, but there was costs that went into me showing up in Brownsville, which this case is in Hidalgo County, Judge. So I will say that all the depositions, I would ask the court that they take place in Hidalgo County, not in Brownsville. McCoy's had an opportunity to hire counsel outside or in Hidalgo County, but they chose to hire who they wanted to. Out of working with defense counsel, who agreed to present the corporate rep back in May, I said, okay, fine, I'll drive to Brownsville. But I mean, I didn't have to do that. The parties are here, the case is here, but I did that anyway. I show up, the corporate rep's not there. I have a videographer there and I have a court reporter there. I have over $1,000 in expenses because he promised to produce them. Then at the eve of the corporate rep, and maybe the day before to that, he says, well, I'm not producing them. I never agreed I would. So these are what I want to bring to the court's attention with regards to what had happened. And so now, the night before the hearing, which is last night, he's saying that he provided at least names or maybe this morning, I'm not sure. I'll let him tell you. He then provided dates for, or provided names of corporate rep. That's not how it works, Judge. I mean, that defeats the purpose of wasting your time, my time, and me simply sending a letter saying, months ago saying, hey, provide these folks. And so I'd like to get into that motion unless the court has heard enough with regards to the corporate rep.
Okay, Mr. Lawrence, do you want to provide any response before we take it up?
Just briefly, Your Honor, the issue has always been trying to identify a corporate rep who could meet all 30 of the topics identified by opposing counsel, which in our view, the topics, particularly the number of the topics, is excessive. But we didn't want to waste the court's time with respect to that. We were able to identify a corporate rep who we've tendered. The only issues is with respect to scheduling. The issue that Mr. Hernandez speaks of was we had communications and I provided dates in which I was available, and that the 2 witnesses that he deposed were available, but I never represented that a corporate rep had been identified or that the corporate rep who was later identified would be available on the date that he's talking about. The reason that we agreed to take the depositions in Brownsville is because, as is the normal practice with respect to taking depositions of folks associated with a party as opposed to independent witnesses, they're typically done at the offices of the attorneys representing that party. My firm has offices in Brownsville, so that was where we agreed to take the depositions and where we would propose to take the depositions of any folks associated with my client, including a corporate rep going on into the future. As he alluded to, I provided him with notice that the corporate rep had not been identified and was not going to be produced on the date in question, well before he traveled to Brownsville, well before he apparently hired a court reporter and a videographer to show up for a deposition that I'd already put him on notice was not going to go forward. So we would object to his request essentially to be, I guess, paid the expenses associated with him and or the videographer and court reporter traveling or appearing to Brownsville for a deposition that he was on notice was not going to take place.
Okay, so just for clarification, on the plaintiff's motion to compel discovery responses, we're going to hold that over at this time. Is that correct? So you can have an opportunity to review?
Yes, Your Honor, I think that makes sense to do.
Okay, if you need that heard, then just file an order resetting hearing.
Okay.
If you feel after reviewing those responses that you still need a hearing on that, you can file an order resetting hearing and we'll set it. Okay, so then on the defendant's objections to plaintiff's deposition notices, are we proceeding on that motion?
Well, I think that's the order setting hearing for the motion to quash, Your Honor. And there's two then motions left, which is the motion to compel the corporate representative and sanctions. And then the second one would be the motion to compel the various witnesses that we have deposed, that we sought to depose, in which counsel quashed.
Okay. And then the orders are in the courts you filed the orders on those as well, Mr. Hernandez?
I would need to, I did file orders before, but I would need to file them based on, after today's hearing, updated version.
Okay. And the reason I ask is because I just look at those for reference as you're making your arguments.
Sure, and Your Honor, I do have, which will make this argument go, I would hopefully, very quickly. If I could share my screen, I do have a PowerPoint presentation to make, and it will just take us through it much quicker.
Okay, so let's get ready to do that. I'm going to go ahead and share my screen, give the opportunity to do that. And then, so we'll take that up.
Okay.
Okay, Mr. Hernandez, you can proceed whenever you're ready.
Okay, Your Honor, thank you. This is a case involving Mr. Gutierrez versus Eric Delgadillo and McCoy's Corporation. Judge, the parties here are the 47-year-old man, just a way of background, that was injured in an 18-wheeler accident, who didn't have any prior medical conditions or injuries in which he suffered from this accident. Defendant Mr. Delgadillo was an individual, or is an individual, that resides in Mission, Texas. And then, of course, McCoy Corporation is incorporated here in the state of Texas. The facts are this: there was an accident that occurred on December 22nd, 2020 in Hidalgo County. Mr. Gutierrez, my client, was a customer of McCoy's exiting the Far store, the McCoy's that's right there by the golf, Top Golf location, in which my client was exiting, making a right-hand turn. Mr. Delgadillo, the operator of an 18-wheeler flatbed truck, was making a right-hand turn as well. He crashed into the client, making in the same direction of travel, who didn't look and see my client that was to the right of him, and so clipped him and crashed into him, causing bodily injury and damage. So we're not talking about a little small accident that occurred here. We're talking about an accident that they're going to argue is low velocity, but caused extreme damage. And I show this to you, and I want you to see this because it is all relevant as to what we're going to proceed and talk about. I'm going to skip to slide 58, which is, I'm skipping over my my motion to compel so that we could get to this. Bear with me. And so this is, we're talking about what plaintiff had to do to get the first, deposition notice. And it's important for the court to understand. There was a certificate of conference sent to Mr. Lawrence. It was sent on March 26, 2021. There was identified several areas in which we wanted a person or persons with personal knowledge to discuss these topics that dealt with an 18-wheeler accident. This is a commercial vehicle which has lots of rules and regulations assigned to it. Defendant ignored this request. They didn't respond to that. So we proceeded and we sent the notice to depose the corporate rep March 31st, 2021, because we hadn't received a response. Subsequent to that, Judge, we were provided a response that said, look, we cannot do this day. We don't know who it is, just like Mr. Lawrence has said. And in the email, he says, pull them down. Pull down the depositions of the 4 folks that you wanted on April 22nd. It's an impossible feat. You talked about 30 people, 30 topical areas. Give us more time. So what do? I say, hey, that's fine. I agree that you get more time. But hey, you know what? Go ahead and provide us a date and time so we can go ahead and get these scheduled. So pursuant to my email here on the screen, Exhibit F, we withdrew the notices that were originally set for April 22nd because he hadn't responded. Now, mind you, this is back in April 6th. So fast forward, we withdraw the notices waiting for Mr. Lawrence's response. Do we get it? No, we don't get it. We continue to attempt to try to get a date from him from August 6th to April 6th to April 14th. We don't get anything. Following up on the date for deposition of corporate rep, we will notice the officer for May 6th and driver and store manager for May 7th. Thanks. So then we don't hear anything. So we serve the notices of these depositions on April 16th. April 16th, we send them. I send up a follow-up email to Mr. Lawrence. Mr. Lawrence responds. He provides the exact location for the depositions of the corporate rep, store manager, and the driver. These emails are exchanged on May 3rd. He says, okay, I was hoping to receive a response to my email, but here it is. If Daniel insists on going forward, the depots will be held at our office on Brownsville, 55 Cove Circle. Okay. Then May 4th, emails are exchanged. Mind you, these depots have already been set for 2 days later. And he says, I'm not producing, we're not producing a corporate rep. Mind you, 3 weeks have gone by. So he's outside of his quash period. Okay. He's outside of the time to have told me that. So instead he waits like he's doing now, dumping a document dump last night. And he says that I unilaterally noticed the depositions. That's just not true, Judge. It's not true. So I tell him in my email, I'm not in agreement to move the McCoy's corporate rep. We've scheduled this for over 3 weeks. I initially pulled down the original dates of the depots that were supposed to have occurred on April 22nd. I've worked with him, Judge. I've worked with him. The depot of the McCoy's corporate rep will not go forward. We will provide new dates as soon as possible. That was his email. Never got dates. We still haven't gotten dates. Then on the eve of the depositions, they claimed the corporate representative was never available. He sends me an email saying that I never made him available. And he tells me, Daniel, can't prove the negative. I never said the corporate rep was available. Well, I mean, what kind of game is that? I mean, I'm trying to schedule the depots. Silence is not. Well, I never said I would. So we talk about showing up. Well, I noticed it. I got an invalid, inappropriate motion, not even a motion to quash. And I even asked him, I said, Chris, tell me, is your corporate rep sick? Do they have COVID? They have a medical condition? Nada, no response. So here I go, show up. Miss Anika Diaz shows up, charged me $585.80 to show up. I got to take a non-appearance. Videographer shows up. We're ready to take depots. We're ready to move this case. $750. Videographer. They're not cheap. Judge, we've been requesting days for the past 6 weeks. I mean, 6 weeks leading up to the deposition. You know, giving us or waiting to the end, you know, to try to cure it, that's not being intellectually honest, one, with one another, but two, we have other cases. We have other scheduling issues that we have to take. And so, Judge, we're asking for relief of the court to order the depots to take place in Delaware County, order them live and in person, and order them on the same day that we have the police officers depot, which is in July. And I'm not asking you to sanction Mr. Lawrence. What I'm asking for is a reimbursement for the costs that my client's going to have to incur to show up, to have to pay this. This comes out of the client's expenses ultimately. And I have to justify it to him why he's being charged twice. So you asked about the relief sought, Judge. Well, here's the relief sought. It's a sample part of the order that I'm going to submit. And it's based on the sanctions, but like I said, it's not a sanction, it's a reimbursement of costs totaling $1335.50 from defense counsel and defendants to be held jointly and severally liable for the reimbursement costs. And then also, Judge, we're asking that these corporate representatives, or now that I'm learning it's more than one corporate representatives, appear live in Hidalgo County on July 8th, 2021. But now knowing that it's more than one, we probably need both days, 7th and 8th. So, Judge, we're obviously, I show this to you because you need to understand the big picture of what's going on. And again, I thought about it. I said, well, you know what? I can make a big deal and charge my time for bringing this motion, to sanction. I don't want to sanction Chris, but I want him to know that my client shouldn't be the one to eat these costs, at least for showing up. And I would ask that they present it at their cost, the corporate rep, that they plan and so desire to present, which would be the order that we will put on file today, Judge. It's not unreasonable. It's not arbitrary to award that. I think his conduct, for whatever reason, whether it's his client or him, it's someone that they understand that they cannot bully people around like that. So that's my motion for this the corporate rep, and then I have the other one prepared to go into the other one. But I would that's what I have at this time for the corporate reps depot and the seeking further costs.
Okay, Mr. Lawrence, do you want to respond?
Yeah, just briefly, Your Honor, as I mentioned before, he was, and as he pointed out, he was on notice that the witness was not going to be produced on the date in question, and nevertheless, he incurred the expense that he's now seeking to recover. So I think that's an inappropriate request on that basis. There was no reason, and it was unreasonable for him to have incurred those expenses of bring a videographer and a court reporter to a location for deposition that he was on notice that would not occur. And it's incorrect to say that there are multiple corporate representatives. We've identified a single corporate representative and tendered that witness. And the dates that he's requesting for that witness, July 7th and 8th, I can tell you I'm not available on those dates, and I know that the witness is not available on those dates. The earliest dates that we would both be available would be in August, Your Honor.
And I obviously, with all due respect, this is the issue that I'm encountering is the delay of this particular process of scheduling depots. I would respectfully ask that we have been seeking this corporate reps depot since March, Judge. We asked for it in April, and then I pulled him down in April. So you see, now he's going to get August, or he wants August. And so that's the kind of game that's playing. So I would ask that the court order the corporate reps depots, and that's unless Mr. Barrera, his associate's going to be. We do have a deposition of the police officer that I've already worked with the City of FAR's counsel, Patricia Rigney, and we do have a date that it has been noticed and going forward on the 7th or the 8th.
Okay, so as far as this motion is concerned, what you're saying, Mr. Lawrence, is you nor a corporate rep will be available on the 7th and the 8th. Is that okay? I mean, is that what you're saying?
That's correct, Your Honor.
Okay. And Mr. Hernandez, you're stating that August is too late to take those depositions?
Well, I think in terms of moving the case forward, obviously, Mr. Lawrence is correct. I do move these cases quickly for my client's sake. It is 141 days old. We don't have a trial date. I will respect and do whatever the court orders us to do. But like I said, it just slow plays it a little bit. And I'm not saying that. It's just I want to get the discovery thing closed. I want to get what we need done. So that's what you get with us as we move them fast. And so if the court says, hey, August, we're going to do whatever the court says. So
okay. And then are you moving forward with your other motion?
yes, Your Honor, if I may, plaintiff's motion to compel the depositions. Now this one is various witnesses in which, as counsel's already stated, there have been 16 folks that we have stated. I will tell you, it's not all 16. In reviewing and conferring with my folks and my team, we've cut out Saul Lopez. So Saul Lopez is not who we're seeking. Again, Judge, just to show the procedural history, we do conference. We do make the attempt, as you see here on the screen. We sent a letter to Mr. Lawrence on May 27th saying, hey, we need to get these depots of these folks. The defendant ignored the letter, no response, okay? After no response, what we're forced to do, we're forced to file our notice of depositions. We filed a notice of depositions. We served those to him on June 10th. Then defense timely filed their quash and sent a motion to quash on June 15th. Aaron Cifuentes, why is he important, Judge? Aaron Cifuentes is important because Manuel Gonzalez, who is the manager for the McCoys in FAR, Texas, states that Aaron is the delivery coordinator. What does the delivery coordinator do? He testified the delivery coordinator dispatches and communicates with the driver. Did so, in this case, for this load, December 22nd, 2020. Also, it talks about the communications that are going back and forth. That's why we need Aaron Cifuentes as depot judge. Armando Rangel. Why do we need Armando Rangel? We need Armando Rangel because he has personal knowledge of the facts related to this truck driver. This is Mr. Delgadillo, by the way. This is who he is. And he was supervisor. He's a supervisor on the day of this crash. He's responsible for making sure that Eric conducted pre-trip and post-trip inspections. This is an 18-wheeler accident, Judge. He also served as a delivery coordinator as well. This is why we need Armando Rangel's deposition. And might I add, this is not a simple automobile accident. This is also a premise liability accident, Judge. It's a little bit more interesting because it dealt with the knowledge of what McCoy's knew about prior accidents involving the ingress and egress of the McCoy's location. So it happened on their property and with their 18-wheeler. So it's a little bit more than just an automobile accident. Mr. Gonzalez, who's the store manager, then states, hey, he's the delivery coordinator as well. That's something that had personal knowledge on because he communicated with the truck driver on that day. Also, why is it important? Because he testified. Mr. Gonzalez testified that he was probably responsible for administering Eric's driver's test, his 18-wheeler accident. He gave him the driver's test that would show his capability or incapability of being able to drive a truck safely. We have the burden, Judge. We have to prove negligence. We have to prove that they acted unreasonably in both training him, hiring him, and him operating the vehicle. Ben Ramirez. Ben was also a delivery coordinator on December 22nd. This is the store manager's testimony. I'm not pulling these names from the sky. These are individuals that were responsible for driver communications, to learning whether they were distracted because they use tablets, they use other forms of electronic devices when they operated, especially Mr. Eric Delgadillo on December 22nd, 2020, Judge. Bernardo Garza. Mr. Delgadillo says, hey, this is a guy that was the outside manager on December 22nd, 2020. He's the one that's responsible for monitoring the hazards on the property. Well, what you're going to hear, Judge, in this case is that they had arrows that were faded. They don't have no signs. And so when you're exiting that McCoy's, which I showed you the picture of, you don't know whether the person in front of you is going straight or making a right or making a left. There's nothing to indicate. There's no delineation of lines of traffic. This is Mr. Garza's job as an outside manager to identify those type of reports and report them to corporate. He also testified that he also performed a driver's test in 2020. We need to talk to Mr. Garza. How did he operate his vehicle? He testimony with regards to discovering information related to this accident, deal with his driving habits and driving safety. Mr. Manuel Gonzalez testified to that. He also, it was testified by Mr. Gonzalez that he was responsible for creating Eric's delivery work schedule on that day in question. Where did he go? What did he do? What was his time limitation? Was he on a time crunch? That's why we need to talk to Mr. Garza. Walkthroughs. Why is that important? This goes to the premises case that we talked about in terms of what are the hazards on the premises, identifying them. Traffic control problems. Was there a traffic control plan done? Who does that? Now, one of the things that's very interesting, Judge, is that there's only 2 hubs. There's only 2 trucking hubs for McCoy's in the state of Texas. 1 in Midland, Texas, and 2 in Far Texas. Those hubs are huge locations to deliver product such as lumber, which has gone up 300%, but we won't talk about that, to other stores throughout Texas. So this is a major, major distribution center that goes in and out with 18-wheelers. Mind you, they only have one entrance and exit. They don't have a separate one. Why? I don't know, but we'll get down to the bottom of that and find out why. Beth Ramey. Who's Beth Ramey?
The head of the training department back in December 22nd, 2020. I believe Beth Ramey. Beth Ramey? Is that correct? Yes.
Beth Ramey. Beth Ramey is the one responsible, head of training, responsible for truck driving policies and procedures. She has personal knowledge as to the policies and procedures that I didn't get till after I took the driver's depot, but that's another battle that we'll come back with. I need to talk to her. She develops these, she's enforcing these. This is coming straight from the manual's mouth. She's headed training and she considers the point of contact for driving safety and training. Here's what he says.
And what about driver policies, safety policies? Who's your point person on that? Driver policy, probably go through training. Okay. And that's Beth. That'd be through Beth. Okay.
Dennis Hernandez. Dennis, who's no kin to me. I know Mr. Lawrence had thought he was, but he wasn't. He was a delivery coordinator as well. And he's another individual, which I won't go into, same information, same personal knowledge that he knew that he worked on that day. Eddie Cantu, not our commissioner, but we established that Mr. Gonzalez knows Mr. Cantu, the commissioner. But his job was also as a manager to perform the daily walkthroughs, which is very important with regards to the premises cause of action that we have. If we're not allowed to take these individuals that have this personal knowledge with regards to the walkthroughs, whether or not they identified the hazards of not having signage, of not painting the strips, the arrows, or they did complain to corporate, but they ignored it. We need to know that. Mr. Lawrence is an excellent lawyer. He understands that premises cases are very difficult for plaintiffs to prove. I understand that. I both defend them and prosecute them. I know what I have to prove. Of course, they don't want me to take these depots. They don't want me to find out that they have been put on notice before. That's the case. Also, Mr. Gonzalez testified that he was responsible for creating Eric's delivery work schedule as well. So another reason on top of that as to why we need to depose Mr. Cantu. It was also Mr. Gonzalez's testimony that he also performed a driving test on Mr. Delgadillo and was also responsible for reviewing his driving performance. Most importantly, Mr. Cantu participated as assistant manager in the investigation of the accident on December 22nd, 2020. What does he have to say? What did he do? He's the inside supervisor at the time of this accident question. He's the one that signed off on documents. Need to talk to Mr. Cantu. He has personal, relevant knowledge, information that will be admissible for the jury to hear.
There's an inside.
James Allen. James Allen demoted Mr. Gonzalez. Why is that important? Well, that's important because there were some complaints about him, affects his credibility, his inexperience as a manager, and the facts surrounding Mr. Gonzalez's evaluation competence in terms of monitoring Mr. Delgadillo. Jesus Garza, this is interesting. So Mr. Garza is important because he was the manager who doesn't have a commercial driver's license, who was told by this store manager, hey, go move the 18-wheeler. So we found out that inside McCoy's, they've got managers unlicensed driving 18-wheelers. How does that happen? Mr. Gonzalez says it. He says he directly handled the vehicle minutes after the accident. On top of that, Mr. Garza is a fact witness. We got to take his depot. Why is he moving a truck, doesn't have a commercial driver's license? What kind of operation are they operating over there? Sean Grimsley. This is important. This is very important. He's head of facilities. He's the person that Mr. Gonzalez says he's the go-to guy with regards to outside the premises, making facility repairs, upkeep inside and outside of it, and determining whether parking lots, the failed proper pavement markings are on there, signage, general upkeep. He has the information with regards to why or what does not exist at the store level and far as a distribution center.
Facilities, yeah, he's in charge of any repairs and POs and everything going on within the stores or facility repairs. Okay, and upkeep. Right. And that's upkeep of the outside premises of the store, correct? And the inside. Yeah. All the property, parking lot, building, inside, outside, everything. Signage, traffic signage on the property, right? Okay. Markings on the road, arrows, correct? It'll go through facilities.
Leroy Garza. Leo Garza is the regional manager who Mr. Gonzalez directly spoke to on the phone and informed him about this accident with his 18-wheeler, Mr. Gutierrez. Mr. Gonzalez's investigation included reporting to Mr. Garza. I certainly have to find out what Mr. Garza told him in response. Mr. Gonzalez was very vague about it, but he said there was a conversation. He did relate facts related to the accident, what to do, what happened, how did it happen. And those are things that he spoke to him about.
Was it your job to let your supervisor know, which is legal, right? Yeah. You're supposed to let him know about what happened.
If there's an incident, I'll just let them know something happened, but all the paperwork and the details, all that goes to risk and safety.
Right, but you told him, you informed him, advised him of what happened on this particular deal, right?
Well, I just told him we had a truck that was in an incident.
Okay.
Rachel Stafford, you mentioned, you heard him mention the risk department. The risk department, Rachel Stafford is the person responsible and who Mr. Gonzalez spoke to and who relayed the crash incident forms to, the photographs and updates regarding the crash itself. She is in the middle of it. And Rachel Stafford has obviously personal knowledge related to the facts surrounding this accident and the truck driver that is imperative to take.
Okay, that's all I need to know. Who did you speak to regarding this incident?
Rachel Stafford.
Okay, who else?
Rachel Payne.
Okay, anyone else?
Not that I recall.
Okay, and what did you talk to Rachel Stafford about?
All the forms being sent in, the pictures being sent in, and just an update on the vehicle.
That was what Rachel Stafford asked of you. The update on the vehicle.
Yeah, for damage or whatnot. And I said, well, we'll get that to you. But that was it. And then she's the one that actually communicated to me when we could put that vehicle back in operation.
Okay. And
Randy Padilla is an individual in the risk department, and Mr. Gonzalez testified that he was the person that was responsible for driver certifications and compliance. So with regards to Delgadillo's driver safety, his habits, his certifications, training, Mr. Padilla was the individual Mr. Gonzalez identified. This is very important. Mr. Delgadillo there's a point system in which the more points you accumulate as a driver, that indicates poor performance or reprimands that you're getting. He was giving points as a result of this crash. And we want to find out what other points he had. He had a prior accident that we knew about where he collided with another parked vehicle. So with regards to the reprimands of this driver, what did McCoy's knew about him as a safe driver? Obviously, we need to know that. That goes to his driving history, what he does not know, what he worked on, and whether the company took appropriate action in the prior accident. So Mr. Padilla was directly, intimately involved in that. Ron Van Winkle is the Vice President of Operations. This individual came to inspect the FAR location. He went to the store personally, and this is the head person for the operations. Mr. Gonzalez identified him as the individual he would talk about store issues. Well, not having signage out there is a store issue. Not having pavement that talk about arrows is a store issue. We need to discover that for Mr. Van Winkle himself, the information that we're not able to get any other way. They didn't have a corporate rep show up. There is no less intrusive matter. And of course, they're going to talk about Apex, and we'll get into that, what Crown says and the affidavit they produced. But Mr. Winkle has direct knowledge. He stepped foot. He flew in a plane or drove to the valley, to the FAR location, and knew about, again, the premises liability. I have to put on notice and knowledge to the company to survive on that. The dangerous condition that existed that they knew about, Mr. Van Winkle was there. He's responsible for company safety, the safety of the company involving incidents like this. Waylon Walker. This is an individual who we talked about before. When I asked Mr. Gonzalez, who do I need to talk to with regards to determining hub stores and the traffic going in and out, it's not a normal store. So it involves a lot more 18-wheeler traffic in and out. And so I need to find out what considerations were made, who knew about it, what JSA's job safety analysis were conducted. And this is who he pointed me to.
who would know, who makes those decisions to determine which store is a distribution hub and a regular store?
Those are just decisions made upstairs.
Corporate, right?
Corporate will make that decision.
And which division of corporate makes that decision?
On operations.
And who sends the operations?
Wade and Walker.
Walker has the information, knowledge with regards to the hub stores, the safety, the traffic. And that's what I want to question him about. Judge, obviously, we're needing these depositions. They've been back and forth. They did not respond. We need the guidance from the court. We ask that you deny their motion for protection and to quash. We ask, Judge, that you order these depots in Hidalgo County live and in person. There's a lot to it, and some would say, well, it's just a car accident. It's not just a car accident. It's an 18-wheeler accident. It's an accident that involves an individual who's been in an accident before. It involves a business store. So we got to get into the corporate aspect of it. Mr. Delgadillo is not going to know about why they didn't paint signs on the floor to indicate arrows of making a left-hand turn. This is the guts of the case in which we got to get into. So, Judge, I won't take any more time, but I appreciate your patience. I appreciate Mr. Lawrence's patience. But I want you to understand, I spent a lot of time on this because I wanted you to know, because in their response, if you look and read their response and their quash, they give you a blanket list of objections. Read those. The blanket list of objections say, hey, these people don't have any personal knowledge. They don't know anything. Well, I beg to differ. They do. And so that's why I wanted to go through it and take the court's time to understand it.
Okay, Mr. Lawrence?
Thank you, Your Honor. This is a low-speed impact car accident case that happened in a parking lot with the scraping action by the trailer against the door. Mr. Hernandez's client told the police officers and everyone else at the scene that he was unhurt. He was walking around the scene. He actually crawled out of his car at the scene. He didn't tell anybody that he's in any kind of pain. He refused medical treatment at the scene. No airbags deployed. He was belted in his seat. There's no evidence that so far that he's even missed any work as an accountant as a result of the accident. I mean, Your Honor, I've been involved in tried cases where hundreds of millions of dollars were in dispute, and we didn't receive testimony from 15 to 20 witnesses. Now, he's already taken the depositions really of the two folks from my client who had the most involvement with the accident itself. And we've already tendered for purposes of allowing him to depose Mr. Padilla and Mr. Cantu. Mr. Padilla was the person who personally investigated the accident. He's a member of the risk department. Unlike Ms. Stauffer, who did not have any involvement in actually investigating the accident and who merely received reports from the field, Mr. Padilla does have personal knowledge of the investigation of the accident. He went to the scene, he talked to witnesses. We've also tendered for deposition the two assistant managers that he requested, Mr. Eddie Cantu and Mr. Bernardo Garza. So, it is not the case that we're trying to prevent all of these folks from being deposed. Many of the folks you'll recall that he was talking about as needing testimony from was because they had something to do with the delivery orders that would have taken place. Well, and or communications with the driver. Well, that all would have been done pursuant to a record that would be part of McCoy's systems. Bless you, Your Honor.
Thank you.
And therefore, the records themselves should speak for themselves with respect to whether or not and what communications took place and what delivery orders were given and received without the necessity of deposing 4 or 5 people on the same issue with respect to, the communication of delivery orders on the date of the accident. Now, with respect to Ms. Ramey, it is not the case that she is the head of training. And in fact, Mr. Gonzalez corrected his mistake in his deposition testimony. She was not the head of training at the time of the accident that we're here about today. So on that basis alone, there's no reason to take her deposition with respect to this accident. I will agree here today to produce or to tender for dates to be deposed Mr. Jesus Garza. Likewise, Mr. Grimsley was not the head of facilities at the time, and that has also been made a part of the deposition corrections of Mr. Gonzalez. So there's no basis to take Mr. Grimsley's deposition. With respect to Mr. Leroy Garza, the only information that he would have received would have been just notification of the accident. It's a fishing expedition with respect to him concerning anything else. I mean, it's kind of like the argument is kind of like, well, I suspect that everybody who worked at the store and probably many of the customers who were at the store probably learned that an accident had happened in the parking lot. That doesn't necessarily make it appropriate to take a deposition of every one of those people. The rules of civil procedure and the cases interpreting it require proportionality. And by proportionality, that's been defined to mean non-excessive discovery given the needs and requirements and issues at stake in the case. And taking that number of depositions on the same topic, basically, for example, on the delivery orders and or any communications that would have been made, is excessive. And you know, that's kind of the point of why the courts, the rules and the courts developed the corporate representative deposition model, because before that existed, I agree with Mr. Hernandez that really, you know, the task that had to be done was you really did have to depose everybody under the sun who may or may not have any knowledge in order to figure that out, right? But not so given the corporate representative model, where you identify a topic and then you have the defendant produce a witness who can testify with respect to the issues on that topic without having to talk to every single person who may have some small sliver of knowledge with respect to that topic. And finally, Your Honor, I would point out that in our response, that Mr. Van Winkle and Mr. Walker, who were corporate vice presidents, are subject to the Apex Doctrine. And pursuant to the Apex Doctrine under Texas law, as provided by the Texas Supreme Court, it is the plaintiff's burden to prove that there is unique and superior personal knowledge that those Apex witnesses would have that is incapable of discovery by less intrusive means. And as he pointed out, the most obvious, and the one we talked about earlier today, the most obvious less intrusive means with respect to any knowledge that Mr. Van Winkle or Mr. Walker may have with respect to this accident would be via the corporate representative mechanism. And so I would strongly urge the court to allow the corporate representative deposition to take place and not create an issue with respect to trying to depose folks at the senior level of management subject to the Apex Doctrine when that's not allowed and no record has been shown to date that they meet the criteria for giving testimony, specifically that they have some kind of unique or superior knowledge. All that he has provided so far is that they may have some knowledge with respect to having, I guess, visited the property, but lots of other people would have visited the property, and certainly lots of other people within McCoy's would have knowledge of the condition of the property who are, for whom testimony can be taken without involving those who are subject to the Apex Doctrine because they're at the senior level of management of the company.
Judge, if I may, this is a level 3 case. So with regards to whether I take 3 depots or I say, based on his witnesses, his client giving me the names of individuals responsible, I have not seen any correction. So if the names of the individuals I'm citing, there was a different person, then obviously we want to substitute that person. We want the person in charge on December 22nd, 2020. backwards. It doesn't change just because this client's going to change his testimony because he got it wrong. That's not my problem. With regards to making sure that the premise case that I'm going to bring forward for my client is very well insulated with facts to survive a motion for summary judgment, which I'm sure Mr. Lawrence will file. I have to make sure that I am talking to the shot callers, to the individuals that are in charge of making those decisions. Mr. Van Winkle, Mr. Whalen, those are individuals with unique and a superior knowledge to make the decisions. They were there, they set foot. One of them did, set foot on the premises himself. So, Judge, if we're talking about narrowing the scope as to the information that I need, let's do that. I'm not going to go ask him what his dog's name is or what he plans to. I mean, you know what I'm talking about. We can narrow the scope of what I need to talk about with these folks, but they need to be deposed because this is a deal that has happened over and over. Mr. Lawrence will not say here on the record that they have never had problems in that parking lot. He will not tell you that. He will not tell you that they have not had a car reverse in parking in the parking lot and almost run into somebody. He won't tell you that didn't happen. But, you know, I had to get to the heart, and they don't want me to get to the heart of it. They don't want me to go and talk to the individuals that know about it because, of course, that's shielding them from the information that I need to have to prove my case. I appreciate the agreement on the record to produce Padilla. I appreciate the agreement on the record to produce Mr. Cantu. I appreciate the agreement for Mr. Garza. You stated you agreed to Mr. Jesus Garza and Bernardo Garza and Mr. Leroy Garza. We're almost there. But there's some more people there that we need to have rulings on, Judge, so that we get those depositions done. And again, the delivery coordinators, let me sum that up, which Mr. Lawrence had talked about. There were several delivery coordinators that Mr. Gonzalez had stated. He said, well, maybe this one, maybe this one, maybe this one, but they are these people. Okay, those depots will be quick. Were you there? Did you work? And I would encourage Mr. Lawrence for them to review their schedules ahead of time, probably, so they can tell me yes or no, rather than, well, I was there. I need to know who those individuals are. These folks, these depots aren't going to take all 6 hours. They shouldn't. And so my client, it's our burden to prosecute the case. It's easy for him to say, you don't need that many people. Trust me, you don't need that many people. Just take 2 or 3. That's how we do it. Well, at the end of the day, he's got a case to defend and I have a case to prosecute, Judge.
Your Honor, just briefly, if I could respond. The reason he doesn't need all those people is exactly what he was just talking about. He's seeking to bind, right, the corporation. He's seeking to establish what the corporation's knowledge is. Well, that's exactly what the corporate representative mechanism is designed to do, is so someone speaks on behalf of the corporation with respect to the issues provided. So there's no, he's essentially trying to pick his own corporate representative and circumvent the corporate representative model, which is he doesn't get to pick the corporate representative. He gets to pick the topics, and then the defendant provides the corporate representative to testify on behalf of the corporation with respect to those topics. So I would argue, Your Honor, that really he's undertaking this exercise, not just to prove up his case, but to be a thorn in the side and an irritant with respect to the normal business operations of McCoy's, and by taking this level of depositions, which frankly, in my almost 30 years of practice for a trucking accident case, is unprecedented.
I've been called much worse. A thorn is, I think, a compliment. I appreciate that, Mr. Lawrence, but I would say that he had the ability to not go down this road had he simply back in March said, here's your corporate rep, Hernandez. Here he is. But he didn't do that. So what happened was it compromised his defense. He put his store manager on there. His store manager told the truth. He gave me the information that I needed with regards to who the individuals are needed. Now, we will cross-check that, right? With the corporate rep that he is now saying he's producing. I didn't get the name of the corporate rep, but he said he's producing him or her. But that does not mean that these individuals do not have personal knowledge or facts that are relevant, that are lead to the admissibility of evidence to aid the fact finder, Judge. He's told you that. I've shown you that. Mr. Gonzalez has testified to that. Mr. Delgadillo has testified to that. The facts are the facts. The testimony is the testimony. I showed it to you. And we would like to proceed with all the depots that we've noticed, except for Saul that I stated. We made an agreement and progress on the folks that he's identified, which I appreciate that. But we still need the head of training. We still need the facilities. We still need those individuals. And if I don't have the right name, if the court could order Mr. Lawrence to provide me the right name of those individuals, that would help lock it down. And we would like to take these depositions within the next 45 days, 60, whatever the judge desires. But we need your guidance, Judge. I don't want to go away from here. There's one thing. I don't want to go away from here without you putting a parameter saying these need to be done by this date, because if not, we're going to be back here in front of you again.
I just want to state for the record, Your Honor, because I think Mr. Hernandez tried to slip in a name that I didn't agree to, and that was I agreed to Bernardo Garza, who had been previously tendered. I agreed to Mr. Cantu, who had been previously tendered. I agreed to Jesus Garza, and I agreed to Mr. Padilla, who had been previously tendered, and obviously the corporate representative, but not Leroy Garza.
I wasn't trying to slip or mislead the court. I apologize if that was the case. They both have the same last name, so we need a ruling on that one.
Okay. So it's been my experience that plaintiffs are not going to take more than the depositions that they need to because they front the costs. So I'm going to deny defendant's motion to quash those 16 depositions. Those 16 depositions will occur, and they will occur before August 31st, 2021. Those depositions will occur in Hidalgo County. The defendant will reimburse the plaintiff the amount of $1,335.50. The corporate representative deposition shall occur before August 31st, 2021. When you all came to me in April and said, in the status conference hearing, I went back to my notes. It stated that you were moving along and that you were getting ready for depositions, and that's what I expected. So I've made my ruling. Anything else, gentlemen?
Thank you, Your Honor. Nothing for the plaintiff. I'll present an order for the court.
Nothing further at this time, Your Honor.
Thank you. That concludes today's docket. Thank you, gentlemen. Have a great day.
No, be excused. I assume we're excused, Your Honor.
Yes, you are. I'm stopping.